Thank you, Mr. Chairman. Ms. Yates, while you were the Deputy Attorney General, was it your policy that both administrations should be treated equally? That is, would there have been any reason from a Department of Justice standpoint to approach an Obama administration official differently from a Trump administration official?
No, Senator, we didn't. And in fact, we made that very determination when I was really insistent that we notify the White House about General Flynn. It was in part because I wanted to make sure that we were treating the Trump administration the same way that we would the Obama administration.
Okay, so had that occurred here, what would that have consisted of? What would it have looked like had you treated an official from the Trump administration the same as you would have in the Obama administration? Who would have been notified before any of this could have proceeded?
Well, when you say any of this, we did do the same thing. We did go to the White House and notify the White House counsel about what we had learned about General Flynn. What would have been different, though, is with respect, I'm not sure why my lights just went out. What would have been different is that with respect to the interview of General Flynn, from a protocol standpoint, I would have notified the White House counsel in advance before that interview.
Okay. Did anything like that happen here? I mean, was anyone from the Trump team notified?
Prior to the interview, no. That was one of my concerns about it, but this was a protocol issue, not a legal issue.
Okay. But that was certainly something that would have been an irregularity. You've acknowledged then that the Obama administration treated the incoming Trump administration differently. The Department of Justice treated the incoming Trump administration differently than it would have the Obama administration.
No, Senator, we were working really hard to make sure that we did not treat them differently.
I understand you were working hard to do that, but that wasn't, in fact, the outcome. The protocol was different. You deviated from the ordinary protocol.
Well, the difference in the protocol here is that the FBI conducted the interview of General Flynn without a courtesy call to the White House counsel.
Okay, when you told when you told Director Comey that there should have been a discussion about recording the interview and raising these things with Comey, he responded with something like, "You can understand why I did this." To which, according to your 302, you responded no, and Comey responded he didn't want to look political, and that you, the 302 also notes that you were offended by that implication. Can you elaborate on this? Tell me why you were offended and what specifically offended you.
Senator, she's probably heard me say too many times now, I was a prosecutor at DOJ for almost 30 years. I prosecuted public corruption cases as an AUSA, Democrats and Republicans. And the way we do our job, or did our job at DOJ, was that you don't consider political implications in making prosecutive or investigative decisions. And I was offended by Director Comey's implication that he would be perceived differently than I would.
Got it. Let me ask you, was it irregular for agents to plan to attempt to, quote, get him to lie so we can prosecute him or get him fired before the interview, as stated in Bill Priestap's notes? Is that an irregularity?
I'm sorry, Senator, I lost our Wi-Fi connection here, and all I heard was at the end, was that an irregularity?
Yes.
Would you mind repeating the question, please?
For agents to plan to get to, quote, get him to lie so we can prosecute him or get him fired.
Well, certainly that's not an appropriate way for the FBI to conduct itself. I don't believe that that's what they did with respect to General Flynn. And I think if you read the 302, it's pretty clear about it.
Is it irregular for McCabe to have pressured General Flynn to appear without counsel?
I don't think they did pressure him to appear without counsel.
All right. Just to make clear, I want to get to the bottom of what went wrong. So, how was a FISA application to surveil an American citizen and a major party presidential campaign approved with 17 significant errors and omissions? And no one knew until the Department of Justice Inspector General conducted an audit. An audit, by the way, that would have never been conducted had the surveillance not involved a staffer of a future president's campaign. Had President Trump lost in 2016, these significant errors and omissions would never have come to light, would they?
Oh, I don't know that. Inspector General Horwitz, I've known him for a long time. He's a very thorough guy, so I wouldn't count on that necessarily being a different result then.
Were you aware that agents were using information compiled by Christopher Steele at the request of the DNC at the time you signed either the initial Carter Page FISA application or the first renewal?
I was not aware that the DNC was funding it, but I think we suspected that there was a chance, but we did not know that to be a fact. And in fact, the Inspector General did not identify that as an error, which, by the way, not to quibble here, there were 7 errors, not 17, and the FISAs that I signed, but one error is too many.
Mr. Chairman, if I can ask one more brief question. Were you aware of the concerns with the reliability of the information that was provided by Christopher Steele and what we now refer to as the Steele dossier before signing either the initial Carter Page FISA application or the first renewal?
No, I wasn't, Senator, and I think a lot of those concerns come from the interview of the subsource that took place after I signed both the original and the first renewal.
Thank you, Mr. Chairman. I see my time's expired.